Welcome to your Series 63 video vault. My name is Dave Meshkov, one of the partners here at Knopman, and in this guided Q&A, we're going to be breaking down some of the toughest topics on the Series 63. We're going to be talking about the registration of persons, agents, and IARs. We're going to be talking about exempt transactions and exempt securities. And of course, we're going to hit some of those differentiations between what's prohibited, what's fraudulent, what's unethical. Let's dive in.
Requirements for investment advisor registration. We've got a multiple question here. Let's go through them and break them down, analyzing each one of the four choices with a accurate or inaccurate tag. If you're not sure, you can always say maybe and then revisit it. When considering the requirements for registering as and conducting business as an investment advisor, which of the following statements are most accurate? So we're looking for two accurate statements. Two will be inaccurate. 1. All employees of an investment advisor must meet the written or oral exam qualification standards set forth by the administrator. Right off the bat, there's a word in this choice that I always am concerned about. Which one? All. That means there are 0 employees within an investment advisor who don't have to meet the written or oral exams. That means somebody who is a clerk, an assistant, an administrator, a custodian, a janitor. All of those people, if they're employees of the IA firm, would have to meet the written or the oral test. Is that true? No, that's not true. So 1 is probably not accurate. 2, an advisor may not be compensated based on capital gains in the account. Okay, an advisor may not be compensated. 2, an advisor may not be compensated based on capital gains in the account. Is that accurate? I'm going to give that a maybe because I'm thinking, as a general matter, that's not something that we have happen. But I am aware that there are exceptions that would allow for performance-based compensation for investment advisors if a client reaches certain performance or qualified standards. 3, an advisor with no place of business in the state and who does business with 5 retail clients in the state is defined as an investment advisor in the state, but is not required to register. Accurate? You got to go back and unpack this one. Classic Series 63 kind of question here where it's complex. So no place of business in the state, so we don't have an office in the state. Okay, I avoided that trap. I do business with 5 retail clients in the state. So that's 5 or fewer. I'm defined as an IA in the state, but not required to register because of what exemption? The de minimis exemption. So 3 feels accurate. Now, I'm not going to pick my choice until I've had a chance to analyze 4. An advisor with no place of business and no retail clients in a state is excluded from the definition of an investment advisor in that state and need not register. So no place of business, no retail clients, excluded from the definition of investment advisor and need not register? I'm not going to go with that one. I'm going to go with 2 and 3 as the most accurate. Municipal securities registration. The Uniform Securities Act provides certain exemptions from state registration for municipal and sovereign securities, depending on specific factors related to the issuer. A broker-dealer is preparing a list of investment options and needs to ensure all securities comply with state registration rules before offering them to clients. Which of the following would not qualify for the state registration exemption under the Uniform Securities Act? We need to make sure we understand what we're looking for. These long questions can confuse and obscure what information we want to show the regulators. So in this case, we are looking for a security that would not qualify for the exemption, which means that security must do what? Which means that we're looking for a security that must register. What security in our choices has to be registered? Is it A, a municipal security issued in a foreign country where the U.S. does maintain diplomatic relations? Maybe. Is it B, a sovereign security issued by a government that has diplomatic relations with the United States? So as between A and B, we see municipal securities or sovereign securities being issued from countries where the United States has diplomatic relations. This highlights that we now have to differentiate between municipal securities and sovereign securities. How would we do so? Well, municipal securities would be things like cities, towns, districts, counties, states, provinces, versus B's sovereign security would represent the national government. As between A and B, my recollection is B would qualify for the state registration exemption. A, I'm going to leave as a maybe. C, a municipal security issued in Canada, so we're back to a city, a state, a province in Canada. And in D, we're looking at a sovereign security issued by the government of Canada, so we're in the national Canadian issuances. I'm now between my municipal issued from a U.S. diplomatic related country that's not Canada, or a municipal security issued in Canada. I remember the special relationship between the U.S. and Canada. I remember that our laws, our cultures, our economies, our systems are so aligned. And so there's less regulatory concern about Canadian securities and Canadian issuers doing frauds on U.S. investors. And for that reason, the security that would not qualify for the exemption, the security that would be the most risky from a regulatory perspective, is A, a municipal security, a city, a state, a town, a province, issued in a foreign country, even if the U.S. has diplomatic relations with that country. So Paris, France, if they issue municipal bonds, would have to be registered. But French national bonds would fall under choice B and avoid registration. They would be exempt from registration. Non-exempt securities transactions. A broker-dealer is advising a client about potential securities transactions that may qualify for an exemption from registration under the Uniform Securities Act. The client's considering several options, each involving a different type of transaction. The broker-dealer advises that certain transactions are exempt from state registration requirements under the Uniform Securities Act owing to their specific transactional nature. Which of the following transactions would not qualify for an exemption under the Uniform Securities Act and would therefore require registration? Long question. The whole middle sentence isn't doing anything other than distracting and confusing you. The nature of this question is, which of the following transactions would not qualify for an exemption? Put more plainly, which of the following is an exempt transaction? Let's take a look. Is it A, the private sale of 500 shares of stock from one individual to another? Private sale, one individual to another. I'm pulling up in my mind the exempt transactions. What does A look like? It looks like the isolated non-issuer transaction. It's isolated. There's no indication that this is kind of a regular offering or a persistent or consistent offering of stock. And critically, it shares from one individual to another, which means who's not getting any cash? The issuer. And if the issuer is not getting any cash, my concern about abuse or fraud is lower. And for that reason, A is an exempt transaction. B, the offer of pre-organization certificates to 9 investors by a broker where a nominal commission is charged for each subscription. So the pre-org certificates, this is a way that an entity can raise money or try and get committed capital before it fully organizes into its legal form. So maybe before it organizes or completes its paperwork to become an incorporated entity, for example, a corporation. Subscription offers are very narrowly defined under the Uniform Securities Act. You can make offers to 10 or fewer subscribers. Offers. So the offer gets counted, not just the sales. And I'm limited to 10 of them. Now, in this case, I've only done 9. But then they offer up this secondary part of the answer choice, where a nominal commission has been charged to each subscriber. Well, if I want to stay in the exempt pre-org certificate world, I have to make 10 or fewer offers with no commission or compensation paid. Because that broker has collected a commission, even if it's nominal, B fails to be an exempt transaction. And so I'm going to say that B is likely our choice. I recognize 9 is less than 10, so we're good on that offer point, but the commission blows the transaction up. Let me check C and D. C, a corporation selling shares of an IPO to a brokerage firm acting as an underwriter in a firm commitment offering. Is this the kind of transaction the regulators are concerned about, where I, as a company, are giving shares to my investment bank to turn around and sell to the public? Is the leg from me, the corporation, to the investment bank a concerning kind of transaction? No. The bank's as sophisticated as it gets. They're not going to be concerned from a regulatory perspective about a corporation selling their shares to the brokerage firm who's going to turn around and sell those shares at a slightly higher price to the public. This choice C is an exempt transaction because it's in connection with underwriting. It would also be exempt because the brokerage firm is an institutional investor. And just from an even further 10,000-foot principle, this is the kind of transaction where the brokerage firm does not need protection. And so we're going to make that easier. We're going to reduce the friction and the regulatory concerns surrounding that. And C is an exempt transaction. D, the sale of 1,000 shares of stock by the executor of a testamentary trust to cover estate taxes owed by the estate. In this case, who's doing the transaction? An executor. How do executors get appointed and empowered? By the court. And so, because the court has put the executor in place, and because the executor is not selling the securities for their own benefit, it's all for the benefit of the estate, the regulatory viewpoint is we're not going to make it harder for executors to liquidate estates. We're not going to require executors to have to go through the process of trying to register securities to sell them, because in that case, they're maybe not going to do it, or they may try and sell them in an exempt transaction and get less money for the estate. And we're less concerned about fraud because, again, executors are appointed by law, by the court. We trust executors. We trust trustees. We trust guardians. We trust sheriffs. We trust, what are all those people called? Fiduciaries. There's one fiduciary we don't trust. Custodians. Why not? Custodians on an UGMA or an UPMA account are self-appointed. And for that reason, we're more concerned about those fiduciaries doing a fraud, and therefore they're not entitled to the exempt transaction. So which of these does not qualify? It's B, not because the number of offers made, but because they charge the nominal commission. Fraudulent versus unethical versus unlawful behavior. What do we got in store for you? Which one of the following best illustrates the distinction between fraudulent, unethical, and unlawful behavior under the Uniform Securities Act? Short stem, but you can already see long answer choices. Be ready for this on the 63, in particular in the ethics sections coming out of Unit 6, and maybe some of the communications questions coming out of Unit 5. With this, we got to be real careful and use our yes, no, maybe technique to make sure that we are answering to the best of our ability. Let's go through each of these together. I assume you have already read and tried to answer this question on your own, so let's see if your process aligns to mine. A, fraudulent conduct involves neglecting to execute client orders. Unethical conduct encompasses front-running client transactions, and unlawful conduct includes insider trading. What I can now see, looking at choice A and skimming B, C, and D, is I need to surface the definitions of fraud, unethical, and unlawful. Before I analyze the other choices, I'm going to try and bring those up based on recall so I'm not distracted by any of the other answer choices. If I can't remember, if I can't recall the definition on my own, then I'll use the answer choices to see if one of those can help refresh my recollection. Fraud, we know, requires intent. Fraud requires that I try and manipulate, deceive, steal, or embezzle from somebody. Unethical means I'm not following the high standards set forth by NASA or the other regulators. And unlawful indicates that I've broken the law or maybe broken some of the rules and regulations that are required. So fraud is going to be the narrowest definition. Unlawful will be in the middle, and unethical will be the broadest, but maybe least consequential. Not that it doesn't have consequences, but it's not going to be as consequential as engaging in unlawful or fraudulent behavior. So A, now I can remind myself, with fraud requiring intent, probably doesn't get me there because it's neglecting executing orders. So that means I forgot to execute an order. That might be unethical, but it's not fraudulent. And for that reason, I'm going to give a no. B, fraudulent conduct requires intentional deceit. Okay, I'm liking that first clause. Unethical conduct may involve conflicts of interest. Sure, a conflict of interest might be unethical. Maybe I'm operating in a way that's totally fine, but because I have this conflict, it doesn't conform to the ethical standards that are required of me as a securities professional. So I like the second part of it. Thirdly, an unlawful conduct entails violations of specific regulations or laws which may or may not necessarily involve fraudulent intent. I like that too. Unlawful is violations of law. Sometimes, if I violate the law, it is fraud. Other times, I violate the law, but I didn't intend to defraud somebody. I just didn't do what the law said I had to. For those reasons, I'm liking B. Let's check C and D just to make sure they're not even more accurate. C. Fraudulent conduct encompasses any activity violating FINRA rules. So if I inadvertently violate a FINRA rule, have I engaged in fraud? No. Fraud requires that intentional deceit, that intentionality to defraud. So C is probably out. Unethical conduct in C is solely governed by NASA guidelines. No, there are NASA guidelines about the ethical practices, but other ethical rules could also apply to me as a securities professional. And unlawful conduct occurs only when a client lodges a formal complaint. Well, that seals the deal for me because I can engage in unlawful conduct even if a client doesn't lodge a formal complaint. In fact, many unlawful activities take place and clients never lodge formal complaints. Clients aren't even aware that they are being victimized. For those reasons, C is out. D, fraudulent conduct is unintentional. Well, we know right off the bat that's not correct. Fraud requires that intent. So we'll finish reading it, but we know D is out. Unethical conduct results in market manipulation. That's too narrow. And unlawful conduct applies exclusively to registered investment advisors? No, unlawful conduct can apply to all the securities professionals. With that, A, C, and D are out. B best describes fraud, unethical, and unlawful behavior. Now, I like this question because it really forces us in the learning environment to understand these three different types of conduct that we have to be familiar with for the regulators for the Series 63. Make sure you have those definitions clear because your questions on the real exam may just ask you about one or the other as opposed to all three wrapped up like this.
Thanks for watching. I hope I was able to shed some light on the challenging topics and concepts on the Series 63 and give you a way to approach and attack those questions. Now, if you like learning in this way, the guided, curated Q&A, don't forget, we've got hours of video just like this in our Series 63 vault. So if you want more of this, go check that out. Best of luck, and I hope to see you soon.